Good morning, South Carolina Realtors. My name is Leanne Watson. I am General Counsel for the South Carolina Human Affairs Commission. I've been with the agency since 2014, and I am very excited about being able to participate today during this training for you all. April is a very busy month for us at the Human Affairs Commission. Fair Housing Month is something that usually requires several of us to be on call for trainings like this. Sometimes it's about, fair housing principles more broadly. But today, the SC Realtors group asked that we give sort of a brief overview of where the agency is and sort of just kind of a general update on the status of fair housing. So with that, I will begin the presentation. First of all, I am an attorney. I am not your attorney. So please don't interpret any of the information today as legal advice for you. I advise you that if you have any questions, follow-up questions from here, that you consult with your own attorney or an attorney of your choosing. You're always welcome to call our agency, and I'll circle back to that later on in the presentation for, information, but we cannot provide legal advice. So keep that in mind. Now, the Human Affairs Commission, or SCHAC, in a nutshell, we are the branch of state government that's tasked with eliminating and preventing unlawful discrimination. We do that through training like this, training and employment. We have affirmative action plans that we approve for all state agencies. We do employment investigations, and we do housing investigations, as you are very much familiar with. All of our staff, about 45 of us, are out of Columbia, and our housing department specifically, since that's what I'm here to talk about, we investigate over 100 cases every year, and there's about 7 people on staff that do that. In the past few years, that has trended upward, and we are investigating closer to 160 cases on average per year based on the last few years that we've been investigating. The conciliation is basically a fancy word for settlement. During the course of an investigation, conciliation is encouraged by the investigator between the parties. And that's actually a requirement that's found in our South Carolina fair housing law. We have to try to seek settlement between the parties before we find a determination either in favor of the complaint and the complainant or in favor of the respondent and the housing provider. If we are able to conciliate a case, that would result in a formal conciliation agreement. And almost always, I would say 90+% of the time, training is a component of those conciliation agreements, so that as we are settling the case, we're also providing additional opportunities to prevent discrimination in the future. Even if it's not found that it's occurred, it's always a good tool and resource to have that training be available for housing providers as they move forward in their business world. Now, when we cannot settle a case, and if we find that discrimination has occurred, that's when I step in, or one of our other attorneys here at the agency. Litigation would result either in circuit court or in an administrative hearing before a panel of our commissioners. And we have to do that. It's not an option. We have to proceed to litigation if we find cause. Now, just as I mentioned that we have around 160 cases that we investigate a year, every year we end up litigating between 4 to 8 cases, unless one of those agreements is reached beforehand. Now, some of those cases, not all, but some can take more than a year, more than a few years to litigate. Currently, my department has 8 open cases pending in either circuit court or before a hearing, and I will talk more specifically about some of those in a little bit. But I know you're most interested in how my department, how this agency relates to you. So I wanted to give you maybe a little bit of hope, or maybe allay some of your concerns. Cases between realtors tend to be few and far between. Surprisingly, just yesterday before I filmed this, I did have one case that I reviewed against a realtor, but that case resulted in a no cause determination. discrimination. So it just goes to show you that either the trainings like this or the level of ethics involved in Realtors Association, educational opportunities that you're engaging in, they seem to be working. It seems like all in all, based on what we're seeing, realtors are abiding by the principles guided through the fair housing law. I can tell you that since I've been here in 2014, there has not been a lawsuit that we filed or a hearing that we've proceeded in against a realtor. Now, when we do get cases that either could result in a no-cause determination or possibly a conciliation predetermination, the cases against realtors tend to be focused on steering. And I'm sure you're all familiar with that concept. I'm of a certain protected class, and it seems like the realtor wants me to be in an area where other people like me are, either based on my race, national origin, familial status, gender, whatever it is. That tends to be the most likely allegations we see against realtors. But just because we're not seeing a lot of cases against realtors doesn't mean realtors aren't involved in our investigation. As a matter of fact, we have had several cases where the realtor winds up being a witness to discrimination. And I wanted to let you know that there was a lawsuit, or I'm sorry, pre-lawsuit, predetermination. We did have a case where the realtor was a witness for the complainant. They had been assisting the complainants in looking for long-term renters. And they had argued, the realtor had argued with the homeowners association about several things in their policies that were in their view, familial status violations that the complaining party, the charging party, was upset about. And we got involved. We began an investigation, and predetermination, that case settled for $46,000 through mediation efforts. Now, I want to make note here that most of our conciliations are going to be public knowledge, and they're mostly found on our website. So conciliation agreements by our law are default publicly available. So a lot of those get uploaded to our website. And so these facts and figures that I'm telling you, they're easily able to be found on our website if you're interested in them. It is rare that we will agree to a private settlement. It does happen from time to time, and you'll hear about one of those later. But just because the settlement might be private doesn't mean the remainder of the case is private. So that's interesting to note. Outside of realtor-based charges, because that's sort of our bread and butter here, we do stay quite busy. HOAs tend to be the most likely respondent that we see. Though we also see housing authorities, property management groups, large commercial landlords, and smaller mom and pop landlords, provided that they're jurisdictional. But these are the more common types of respondents that we see, as opposed to allegations against realtors. So keep it up. Our most commonly litigated cases are based on the protected class of disability. And actually, that's also the most commonly filed investigative complaint. Within that context, we see a large number of assistance animal complaints. So you see my cat and dog here. That tends to be the most likely type of allegation that we see among the broad spectrum of allegations that might come into our office. So just sort of an update on some litigation we've done. Last summer, we settled 2 assistance animal cases. Both were out of Horry County. The first case was filed by a housing seeker who had a medically authorized dog and was rejected from renting an apartment due to their no pets policy. Respondent stated to our investigator that the animal would need to be, quote, trained, be, quote, certified to circumvent the no pets policy. But the commission's position is that an animal need not be trained or certified by any online certification program in order to qualify as an assistance animal under the Fair Housing Act or South Carolina Fair Housing Law. That the medical prescription, more or less, was enough to make that animal legitimate under the law. And so the respondent's failure to accommodate the agreed parties' needs to live with with her medically prescribed animal was unlawful. And then that case actually did settle for a confidential total in September. Now, the second case, also again out of Horry County, was an individual who had her assistance dog living with her, but the Property Owners Association was restricting where she was authorized to take the dog. For instance, there was only one elevator that she was allowed to use. And our position was that the denial of her ability to get around the complex was denying her the equal terms and conditions of living at the property. So that case settled with $7,500 going to the aggrieved party in damages. And it also resulted in a $2,000 civil penalty that came to the agency. That's permitted under both the Fair Housing Act and the South Carolina Fair Housing Law. Civil penalties to the agency that brings the case are permitted. Right now, the cap is at around $21,000, just a little bit over that, but it rises every year to 3 years based on what HUD puts out in their regulations. Now, we do have some pending cases. As you see here, we have one active assistance animal lawsuit currently that's out of Greenville County against a landlord and property management group of an apartment complex. We have one pending hearing as well, and that one's out of Darlington County against a housing authority. Of our other pending cases, we have what I call access to property cases under disability. So sort of like the emotional support animal case in Horry that settled. This doesn't relate to an animal, but it's about the individual themselves being able to get access either to common use areas like the parking lot, a clubhouse, or some other type of amenity that they're struggling to get access to. So we have one of those in Richland County and one in Charleston County. We also have a pending sexual harassment case against a small landlord in Beaufort County. We have a familial status matter out of Colleton County. That's another landlord situation. And then we have a retaliation case in Lexington against an HOA. I wanted to talk about the oldest case that we have on our pending inventory. It's this last case. It's a familial status case. SCHAC versus Chin et al. Out of Charleston County. This is a familial status case where the landlord was preventing anyone with children the opportunity to rent certain units on the property. Our aggrieved party arrived with her daughter and was denied the opportunity to look at the property. She filed her complaint with our agency in 2013, so 8 years ago. And then our agency filed a lawsuit in 2014 in Charleston. It has not yet been resolved. Following several motions in 2017 and 18, our agency actually lost certain motions and the case was dismissed. So we appealed. It ended up being a South Carolina Supreme Court issue, and they sent out an order this past July that was partially in the agency's favor, partially not in our favor. The part that wasn't in our favor related to our argument that a mediation agreement that had been signed in 2016 should have been enforced against the defendants following a mediation agreement being entered. The defendants went back on that agreement after signing it, but because their attorney had not signed that contract with them, the court ruled that it was unenforceable under Rule 43K of the Rules of Civil Procedure of South Carolina. So we lost on that point. But more importantly, we were successful in arguing that parts of our law that had been deemed unconstitutional by the circuit court judge were not found to be unconstitutional. And that has resulted in the case being remanded or reinstated back in circuit court in Charleston County, rather than us facing the dismissal that we had in the lower court. So just to reiterate, this case has not been fully resolved. However, we do have some dispositive motions on the horizon, one of which has already been heard, the motion for summary judgment in our favor, which was granted just last week. Now, there is an intersection between you guys, realtors, and employment matters. So I know the focus this month is on housing, but while I have your rapt attention, I wanted to bring up a couple of new developments that may not be on your radar related to employment. So I would imagine most people that are watching this training may either be employees of an employer or maybe employers of some employees. And so it's good to know that there have been a couple of new acts passed in South Carolina in the last few years that relate to employee rights at the workplace. So the first is the Pregnancy Accommodations Act, which was signed by Governor McMaster in 2018. And that states that any typically jurisdictional employer, and when I say that, it's a little bit more nuanced than this, but think if you have 15 employees, you're going to be jurisdictional. 15 employees. If there's a pregnant employee that seeks an accommodation for her pregnancy, then the employer must engage in an interactive process to determine whether or not that accommodation can be given, an alternate effective accommodation can be provided, or to explain why it would be an undue hardship on the employer to provide that accommodation. And I'll give just a couple of examples here. Let's say a pregnant employee needs to be able to eat or drink on during her working day. She should be given that opportunity. If she needs more bathroom breaks, she should be given that opportunity. Again, absent some sort of undue hardship or an alternate accommodation that might be posed by the employer. So that is something that we do training on, and I would encourage you to reach out to me if you would like training on the Pregnancy Accommodations Act, because we do have a fairly robust training program on that and other types of accommodations that would fall under, say, the ADA or the Americans with Disabilities Act, if that's something you're interested in learning more about. Now, I talked about jurisdictionality with the 15 or more employees for Pregnancy Accommodations Act. For the Lactation Support Act, which was just signed this past year, that applies to any employer regardless of size. So even if you've never been an employee or an employer in a relationship that's jurisdictional for our agency or our federal counterpart, the Equal Employment Opportunity Commission, the Lactation Support Act provides broader coverage to women who seek to express milk during the workday at their job. So any employer is expected to take in requests for accommodations by women who need to express milk and provide them with the time, the place that needs to be a private place other than a bathroom stall in order to express milk during the day. So, of course, there's still that, ability to explain why it might be an undue hardship, and that should be able to be explained to both the employee and to us should a charge result. But that is for all employers, regardless of size, and it's something to be very careful of, whether you're an employer or to be aware of if you're an employee. So now that I've covered just a little bit of housing, I'll wrap it up by saying if you have any questions, because I've tried to keep this brief, please feel free to reach out to me. And if I can't answer your questions, I'll be happy to put you in touch with someone at our agency or in state government that hopefully can. My contact information is here, and I really appreciate having the opportunity to speak to you. And I hope that I gave you at least some information that you didn't have before. Enjoy the rest of your day and happy Fair Housing Month.